Today I want to talk about the latest update in a huge case that could have had huge upheaval for firearm sales in Canada. Now, I also owe you guys an apology because I've been meaning to cover this one for forever. It came out in March, but I'm getting to it now, so let's have a look. This is the case of Price and a bunch of other people against the Smith & Wesson company. Now, what happens in this case is that they're suing over the Danforth shooting. So what happened in that case is that a person with a Smith & Wesson firearm walked down the Danforth and shot at a bunch of people. So let's see how the court describes it, but we'll talk about what this is, what the lawsuit is, and what the latest developments were. So the tragic events giving rise to this proposed class action, which events have come to be known as the Danforth shooting, were that an M&P 40, and M&P stands for military and police, which does not utilize authorized user or smart gun technology, was stolen. The M&P 40 came into the hands of Faisal Hussein, who during the evening of Sunday, July 22nd, 2018, walked along Danforth Avenue in Toronto, Ontario, and randomly shot and killed 2 persons and injured others, some of whom were shot and some of whom were injured fleeing the active shooter scene. The Danforth shooting ended when, after exchanging gunfire with police officers, Mr. Hussein used the M&P 40 to kill himself. Okay, so this is a fairly heavy situation, but what they're talking about with authorized user or smart gun technology is technology that limits the use of the gun to sort of people who are approved. Now, this technology is not super popular with firearm owners for a number of reasons. One, sometimes we lend each other our guns and so forth. You know, somebody comes up to you at the range and they're like, "Hey, that's a really cool gun. Can I shoot it?" And I'm like, "Yeah, absolutely. Why not?" But the other thing is that a lot of these technologies, I think all of these technologies that I've seen, have big problems with reliability. As an example, this is the firearm or one of the firearms that I use for competition shooting. I need it to work every single time. Competition shooting is based on, time and accuracy and so forth. And a gun that works 95% of the time is a garbage gun. You need it to work every time because if it fails, then you've just blown your score. Now, this is just competition shooting. If I blow my score on a competition, oh well, no big deal, I'll live. And the live is the key thing, because if you're talking about a firearm for defensive use, such as the use that police might put it to, then it needs to work every time. When you see the detail here about after exchanging gunfire with police officers, if the police officers were unable to exchange gunfire in that scenario because they had authorized user or smart gun technology that didn't work, they might have been in a lot of trouble. So that's why this is not super popular. But this lawsuit was about trying to force and trying to hold Smith & Wesson accountable for not putting this technology in basically every gun that they sold. And so if successful, you would see that basically every gun manufacturer would have to include this, and that could be a real problem. Even hunters don't want this, because if you've got that shot lined up, you've got the deer, the shot on the deer, the ideal shot, might be available for 2 seconds, right? It's the deer, sort of turns, you get the perfect shot, and then it catches wind of you, it smells you, and it runs away. So if you are sitting there fiddling with the gun and trying to get this smart gun technology to work in those 2 seconds, well, you've just ruined your hunt. Okay, so they also wanted this certified as a class action so that they could all proceed together, share the legal costs, and then, based on that, they could then proceed to sue Smith & Wesson in sort of a more economical way and a way that might facilitate their litigation. So this is about whether or not they get certification as a class action, but it's also a little bit about whether they made good arguments. So let's have a look. So the court continues, by way of an overview, to satisfy the common issues criterion, part of seeking a class action, the plaintiffs needed to establish that there is some basis in fact for a design negligence products liability cause of action. As the discussion below will demonstrate, this proof entails a great deal more than the assertion that the manufacturer of an inherently dangerous product does not have the right to manufacture an inherently dangerous article when a method exists of manufacturing the same article without risk of harm. Amongst other things, the plaintiffs needed to show some basis in fact that the M&P 40 has a design defect, which is a vastly more difficult matter to prove than proving that Smith & Wesson had already developed patents for a prototype of a gun with authorized user technology. One of the arguments that the plaintiffs here were making, and I previously covered their sort of first round on this case, was that Smith & Wesson held a bunch of patents for smart gun technology. But one of the issues is that having a patent doesn't actually mean anything. I could go and patent all sorts of things, but it doesn't mean that the invention that is being patented is necessarily workable or cost effective or in some cases even possible. You can patent things that might not actually work in practice. So for phase 2 of the certification motion, the plaintiffs did not proffer evidence from an expert in firearm design. This is going to be a big problem for the plaintiffs in this case, and it cannot be inferred from the expert and observation evidence that the plaintiffs did proffer that there is some basis in fact for the allegation that the M&P 40 has a design defect. In the immediate case, the plaintiffs established some basis in fact that Smith & Wesson had the capability of designing a prototype of a firearm with authorized user technology. However, there was no basis in fact evidence to show that there were any common issues about design negligence in the M&P 40 that was designed and then manufactured without authorized user technology. So this is one of the common things in court. You don't just have to have a good argument. You have to have evidence to support it. And they brought a whole bunch of experts, but they didn't bring the right experts. They didn't bring experts in firearm design. And we'll see a little bit about why. There's a common trend in their experts, and it really, really blew up their case. We'll talk about that. We'll discuss what selection criteria they used for experts and why it was a bad idea if they wanted to have a winning case. So, in the immediate case, it can obviously be inferred that the M&P 40 creates a substantial risk of harm because it's a gun, right? If you shoot someone with a gun, they might die. They're likely to die. However, it cannot be inferred that there is some basis in fact that the plaintiffs proposed alternative designs for an M&P 40 utilizing authorized user technology would have minimized that risk of harm at a reasonable cost. You'll note that the provisos here, it's not just minimizing the risk of harm, it's also at a reasonable cost without impairing the utility of the M&P 40 for its intended use as a military and police weapon, or even for just its use as a handgun for whatever purposes. So it also has to not impair the utility, and that's been the big problem with smart gun technology. Lots of people love the idea of, hey, this gun only works when I hold it. The problem is that people haven't loved actually using those guns. And they haven't loved the fact that those guns typically are way more expensive than a gun without those. So these have not been popular technologies. And especially when you're dealing with military or police, the failure rate has to be zero. It's got to be basically zero. When you see military criteria for when they're testing out a new gun to see if it might be adopted, they'll say, okay, you're going to shoot this gun 10,000 times, and the allowed number of failures before this gun is removed from consideration will be something like 1 or 2. And that's it. Whereas these things have not been anywhere near that. The other thing about military and police use is that police might have really good reasons to need to trade guns. They're often stored in like a central armory. The police, and there have been police, use of force incidences where, for instance, one officer is downed and another officer ends up picking up their gun. Not exactly something that, so for those reasons, these are not great. They continue on. In the immediate case, and I'm skipping over a lot of this case just to get you the meat of it, but I will link the full case in the description below if you want to read the parts I skipped over and check my homework. So in the immediate case, the plaintiffs have a public policy argument that all handguns should have the authorized user technology as a product standard. Now, this sounds good, right? This sounds like a good thing for the plaintiffs, and it's actually, as a lawyer reading that, I'm like, oh, this is death. And the reason why is because public policy often isn't what the courts are doing. The courts aren't lawmakers. The courts they adjudicate legal issues. A public policy argument is one you take to Parliament, not to the courts, typically. So they say, but a public policy argument is not the same thing as a design negligence cause of action against a handgun manufacturer who made design decisions to not incorporate authorized user technology in a handgun that it was manufacturing as a military and police weapon. In the immediate case, the plaintiffs offered polemic, but not proof of the common issues criterion and the preferable procedure criterion. These are two tests for certifying something as a class action. It is a remarkable feature of the immediate case that, unlike most, if not all product liability class action certification measures or motions, Smith & Wesson did not cause any expert evidence on the critical issue, which in this case was handgun design. I'll return to this remarkable feature in the discussion below, but this aspect of the case does not alter the circumstance that the plaintiffs did not satisfy the very low standard of establishing some basis in fact for the common issues criterion and for satisfying the preferable procedure criterion. So normally the people responding it would call some evidence on this, and Smith & Wesson made the decision. They said, we don't have to. We've got the winning cards without anything. So we're not calling any evidence. And that's it's a bold choice, but it worked out for them here. Okay, so let's have a look. We're gonna skip over all of this stuff, well, a lot of it because it's procedural, but we are going to look at this bit here. So the plaintiffs delivered a supplementary motion record comprised of the following. So an affidavit from Najma Ahmed. I don't know, I might be mispronouncing that, but she is involved in anti-gun activism. She's a anti-gun activist. The next is the affidavit from Ralph Blake Brown, who is also an anti-gun activist. They note his main field of research is Canadian legal history. And he's authored numerous articles about guns and gun control in Canada. And he's also someone who has repeatedly tried to cancel me on Twitter with very limited success. But yeah, he also scrubbed his Twitter before he testified in a different proceeding because, yeah. So again, another anti-gun activist. Mark A. Chapman, I don't know as much, but whose law practice focuses on patent infringement lawsuits. I'm going to assume he's neutral because don't know him as much. Same thing with Peter Edmondson. We'll assume he's neutral. He's not a name I recognize. They've got Pamela Good, retired lawyer who during her 30-year career worked for the Ministry of the Attorney General. Among other things, she was a member of the ministry's Guns and Gangs Initiative and legal counsel to the Chief Firearms Officer of Ontario, providing legal advice respecting the Firearms Act. We'll cut her the benefit of the doubt, but I will note that the Ontario CFO does not exactly have a great reputation within the firearm community, but we'll cut them some slack. They do have somebody who was a member of the U.S. Marine Corps and a commissioned officer in the United States Army or U.S. Army Reserve, certified by the NRA as a pistol instructor, okay, and licensed to carry a concealed handgun. So they've got somebody who is more familiar with firearms. That's good. They've got an affidavit from somebody who worked for the Center to Prevent Handgun Violence. And you've got another, Juyung Kim Lee, another person who has written extensively on gun violence, particularly within ethnic urban communities in the United States, articles about gun violence, so another sort of firearm activist. I'm just going to say this is not the suite of people that I would be looking for if I'm trying to run the case for the plaintiffs, because you want to get people, and what the court has said here is the court has said you needed somebody who was an expert in firearm design. And you're not going to find an expert in firearm design among this crew. It seems like it's the wrong group. So, skipping on here, we'll go to the negligence in design question. In their factum, the plaintiffs describe the theory of their case as follows. So this is how they think they should win. The essence of the cause of action is that Smith & Wesson was aware of the risks posed by lost and stolen handguns, yet sold products in Canada without any safety devices, mechanical or electronic, to prevent unauthorized use. Safety devices were not included, even though the company's products were frequently lost and stolen in Canada, recovered at Canadian crime scenes, and the subject of crime gun traces by Ontario law enforcement agencies. The agreement Smith & Wesson made with government authorities in the United States, the patents obtained by Smith & Wesson for authorized user technology, and the actual sale of M&P 40 products in the United States with internal locking mechanisms all show that Smith & Wesson recognized the risk of unauthorized use and developed technology to make its products less susceptible to unauthorized use. There is a basis in fact before the court for 5 proposed common issues, all of which depend on the defendant's conduct in exporting the handgun to Canada without including any device, mechanical or electronic, to address the risk of unauthorized use and the later theft and misuse of the handgun to cause devastating harm in the Danforth shooting. So the court says the predominant and fundamental concern or common issue in the immediate case is whether Smith & Wesson was negligent in designing the M&P 40 by failing to adopt authorized user technology. So if they had found that they were negligent, then essentially every gun in Canada would have had to later have authorized user technology, because no gun dealer would want to sell without including these locks. So you can see why all of the sort of anti-gun activists I mentioned who were cited would have been all over this one, right? Because really it would have drastically reduced the number of firearms for sale in Canada. And just a lot of gun manufacturers would have said, we're not dealing with Canada at all, which I'm sure would have made those folks very happy. Since this case is exclusively a design negligence case, it is helpful to understand the law associated with negligence in design before analyzing whether there's some basis in fact to satisfy the common issues and preferable procedure criterion in the immediate case. So the underlying argument in a design negligence action is that a manufacturer has a duty of care So a duty of care is an important part of negligence. Do you owe a duty to somebody? And usually, a lot of the time, this is fairly easy. If I fail to shovel my walkway out front of my house and somebody slips and falls, did I have a duty of care to sort of the ordinary person who might walk on that walkway? Yes, right? If I'm driving the car and I decide, you know what, I just wonder if I could drive the car with my eyes closed. Well, I owe a duty of care to other members of the roadway. But let's say I'm in my house and, I am sort of playing with my pen. And somehow somebody, I'm doing this on a live stream, and somehow somebody out there in the universe sees this pen and has some sort of, traumatic. Do I owe every person in the universe a duty in that? No. The duty of care aspect is really to sort of limit the sphere of people who can sue you to those who might be sort of within the ambit of who you should be worrying about when you're taking actions. So, did they have a duty of care not to design a product negligently because the manufacturer should and can fairly be held responsible for the choices it makes that affect the safety of the product? The manufacturer has a duty to make reasonable efforts to reduce any risk of life and limb that may be inherent in its design. So this is now reasonable efforts. Reasonable does a lot of heavy lifting there because you're not required to make every effort, right? Certain things, and if you think about making every effort, at a certain point, everything we deal with becomes completely unworkable. There's probably some way to make a kitchen knife such that it can't possibly be used to cut anybody. You could theoretically envision a gun that has a little camera on it where you have to pay a subscription service and that video goes to like some other person who reviews your use of the gun so that every time you pull the trigger, it sends it off to them, and until they review the video and say, yes, approved, it doesn't shoot. But that would be a garbage product, and it would be incredibly expensive, and it would be stupid, right? This is an obviously dumb hypothetical. But it might reduce the risk a little bit. So, okay, cool. Now, of course, the first thing people would do when they got that gun would be to disable that feature. But yes. In the case of negligence in designing a product, the defendant is blameworthy for not designing its product in a safer manner. So in Nicholson and John Deere Limited, Justice Smith noted that a manufacturer does not have the right to manufacture an inherently dangerous article when a method exists of manufacturing the same article without risk of harm. Now, again, it's, within reason and so forth, right? You can't just say, oh, there's a method, but it has to be it has to be such that it would be unreasonable not to include it. So let's imagine, you've got a lawnmower and your lawnmower's got like a little metal skirt kind of thing that prevents you from easily putting your foot into the blade as you use the mower. That little skirt, part of the case pretty much costs nothing. It's not hugely expensive. And so it would be crazy to manufacture a lawnmower where you've got this lawnmower blade that just spins out openly and, takes out the dog, takes out your legs, takes out everything. That would be crazy. So you can't do that. Somebody could sue you for doing that. But other features, it gets more complicated. To succeed in a cause of action for negligent design of a product, the plaintiff must identify the design defect in the product and establish that the defect created a substantial likelihood of harm and that there are safer and more economically feasible ways to manufacture the product. The law does not require a manufacturer to produce articles that are accident-proof or incapable of doing harm. Think about this in the context of motor vehicles, right? And sure, we've got tons of features in our cars that are designed to make it less likely that we'll have an accident and more likely that we survive in an accident. We've got seatbelts, we've got airbags, we've got, lane assist, we've got all of these things. We've got headlights, we've got so many of the features in our cars are designed to make them less likely to get into accidents and more likely that we survive. But if they had to make cars impossible to get into accidents with, we just wouldn't have cars. And I know there's some people in the, watching this will be going, great, bring on the age of bicycles. And I will tell you, it is impossible to make a bicycle that is accident-proof or incapable of causing harm as well. Even a kid's tricycle can have an accident and can cause harm. So we'd pretty much be just, the only product we could have would be like helmets and rubber padded rooms. So, but a manufacturer does have a duty to design a product that is not defective. Depending on the product, defectiveness may be determined in relation to the design of the product based on a risk-utility analysis of an alternative, safer design of the product. Note risk-utility. You could theoretically make a car that goes at no more than 1 kilometer an hour, such that any accidents you have in this car are going to be pretty safe. You crash into a wall at 1 kilometer an hour, nobody dies. However, is that a useful car? Is that helpful to anything? What are you going to do with this car? You're going to throw it out because that's not useful. So that would fail on the risk utility analysis. Sure, it's got less risk, but there's no utility left in the vehicle. So in Kreutner and Waterloo Oxford Cooperative, the Ontario Court of Appeal noted that to succeed in a claim of design negligence, the plaintiff must establish, among other things, that there exists an alternative design that is safer and economically feasible. Feasibility in this context means more than that it is possible to manufacture a safer product. It means that the safer product can be manufactured without unduly impairing the utility of the product and without greatly increasing the product's cost. You know, let's say your airbag makes your $15,000 car cost $15,200. That's not a big cost. But let's say it makes your $15,000 car cost $45,000. Well, then nobody's buying this, right? So these are considerations. The court basically says these laws have to be reasonable. It has to be practical. The law can't be insane about how it goes about doing this stuff. And thankfully, the court considers that even though we're talking about guns, because it is very easy for courts to basically say, listen, just because this is guns, we're going to turn off our brain and we're just going to say no deal. There are court cases where I think the court has done that. But this is not one of them. The court is going to say, listen, we have rules, you got to follow them. All right. So now we get to the question of common issue number 1 about design negligence in handguns. Was the defendant negligent in failing to incorporate authorized user technology in the handgun used in the Danforth shooting? So the immediate case is about the design of the M&P 40, which, like all handguns, has lethal capability. Now, that's not technically true because there are things that are handguns in Canadian law that are not lethally capable, but we'll just give them this one. This is a technicality that I spot, but it doesn't matter for this case. The plaintiffs allege that the M&P 40 was designed for military and police use and was intended to injure or kill people. Fair enough. It totally was, right? That's why the police and the military carry it, is that it can do those things. The phraseology used by the plaintiffs attributing intent to the M&P 40 is problematic because guns, being objects, have no mental states, including intentionality. So, the court here basically says, you are saying the gun has a purpose, and this is basically the court sort of going a little bit on the, guns don't kill people, people kill people kind of thing, right? So what the plaintiffs obviously mean is that the M&P 40 was A, designed to be used by the military and the police, and B, it was designed to enable those users to injure or kill people. This observation is not to embroil this case in the slogans of the American NRA, National Rifle Association. Rather, as will become evident from the discussion and analysis below, to be fair to the arguments of both parties, it is necessary to be precise about the purpose, capability, feasibility, risks, benefits, costs associated with designing the M&P 40 as a manufactured product with purposes, not intentions. I like the way the court deals with this. The court is like, I don't want to get into slogans, but we do need to actually deal with this as a, what is this gun for? What is its intended purpose? So Smith & Wesson submits the plaintiff's proposed class action is stillborn. Okay, that's a choice of words, but fair enough. And there can be no basis, in fact, for this critical common issue without an expert qualified to opine about design, to opine that there was an alternative design for the M&P 40. So why couldn't they get an expert qualified in design? Well, I'm guessing because the experts qualified in design, A, probably don't fit their sort of goals here of sort of, there's a lot of gun control proponents on this one, on, their sort of side here. But also, I'm guessing they might not have said the things that they wanted said. that's a problem too, right? Sometimes you shop around for an expert and you just can't find one to say the things you're hoping to say because they're just not true. So, without an expert qualified to opine about design, to opine that there was an alternative design for the M&P40 that A, would have minimized the risk of criminal misuse of the M&P40, B, could have been adopted at a reasonable cost, and C, would not have impaired the utility of the M&P40. The plaintiff submitted that all they needed to do with the certification motion was to prove that there was some basis in fact that Smith & Wesson knew that lost and stolen guns were frequently used by criminals. Smith & Wesson knew that authorized user technology would make the M&P40 a less dangerous product, and it was feasible for Smith & Wesson to incorporate some form of authorized user technology in the design of the M&P40. And D, for Canada, the incorporation of authorized user technology would not adversely impair the utility or the functionality of the M&P40 by private users, because under Canadian law, the use of handguns in the private sector is limited for target shooting and for gun collecting. Now, here's the thing. As a target shooter, I don't want authorized user technology because I want my gun, the gun I use for target shooting, to be as simple and to have as few failure points as possible. Now, I am waving my hand here and I just want to illustrate something. I am waving my hand substantially out of this. This is a gun that is unloaded. Everything is, we're being safe here. We got a safe direction, all of this. But, I don't want the handgun to have authorized user technology because even though I'm an authorized user, I don't want it to hiccup on this. I don't want to have that kind of problem where I go to fire at the target on the clock because so much of target shooting is timed. And then it just goes, beep, please re-authenticate. It's like, I can't be re-authenticating when I'm on the clock. Sometimes I have to shoot with gloves. Some of the authorized user technology involves like fingerprints or grips or those kinds of things. I don't know if the gloves are going to make it up. Why do I have to use gloves? Well, sometimes I shoot in the winter and Canadian winters suck. What if there's an RFID? What if there's some sort of signal jamming? What if, all of these things, right? I just don't want that. I don't want those headaches. I just want something simple and effective and reliable. The plaintiff submitted that the vast majority of Canadian gun owners would be minimally impacted if the feasible authorized user features had been incorporated into the M&P40, and the Smith & Wesson could have and ought to have incorporated this technology. I probably could have testified as to the opposite of this. I could have testified that they're wrong, but Smith & Wesson did not call me to testify, and I would, if they had, I would have recommended better experts than myself, but yep. Boldly, by the way, it is never a good thing when the court says that you are bold. Bold is praiseworthy all sorts of places. If I say, oh, my buddy is bold, I'm talking him up. I'm bigging him up. But if the court says that you are bold, it means you're dumb. Boldly is you screwed up. You have said something you shouldn't have said. Boldly, in their factum, the plaintiffs asserted that more detailed evidence relating to a risk-utility analysis cannot be required at the certification stage, because in a product liability case, there is an inherent informational imbalance that favors the manufacturer, i.e. the manufacturer is sitting on all this information and they don't have it, who has yet to have been exposed to documentary and oral discovery. The plaintiff submitted that it is unfair to require a plaintiff to provide evidence that relates to matters exclusively within the manufacturer's specialized knowledge. The thing is that they can still do analysis of risk and utility, right? It may not be the same as Smith & Wesson's, but they're not held to proof here. It's just that they have to have some useful evidence on these points, and they didn't. So the court notes, even at the low some basis in fact standard, and I'm adding the quotes there because I thought they should have been in there. The standard is some basis in fact. the plaintiffs do not satisfy the evidentiary threshold for the critical design negligence common issue. A design negligence case ultimately requires evidence from an expert in design. Evidence about the consequences of alleged bad design just begs the question of whether the design was bad. Begs the question basically means you're assuming the conclusion. So here in this case, they're saying, look, there are dead people, and that is tragic. But that doesn't say that it was bad design. You have to actually have an expert in design to say this is a poor design, right? The fact that somebody loses their toes in a lawnmower accident doesn't say it was a badly designed lawnmower. Maybe it was, but maybe there's reasons for the design. Maybe, and so you need an expert in lawnmower design, right? And that person can say, yeah, this should have had all of these basic safety features and it didn't. Or it could be that the lawnmower design expert says this is one of the safest mowers on the market. If this guy lost his toes, he had to have been operating it drunk or something like that, right? I don't know. The plaintiffs are not required to prove the merits of their design negligence case with expert evidence at certification, but they're required to show some basis in fact for the rudimentary elements of a design negligence claim that has possible merit. The plaintiffs must show a plausible methodology to prove their design negligence cause of action. So because they're not actually at trial yet, they don't have to prove things, but they have to outline for the court a path from where they are now to Victory Town that doesn't have like a giant wall or an impassable chasm or an ocean between them. They have to show here's how we would get there. And the plaintiffs in this case couldn't do it. The court notes, typically, in a design negligence proposed class action, the plaintiff will call a design expert to show some basis in fact for the common issues about negligence in design. The plaintiff may suffer an information deficit about why, when, where, and how the defendant made the design decisions that it made, and about whether the defendant met the standard of care in making its design decision that it made. But the plaintiff does not suffer any information deficit in identifying what the common design or what is the common design deficit or defect. And moreover, there is no information deficiency in at least establishing the methodology for making a risk-benefit analysis. The court here is being a little bit critical of the plaintiffs for failing to bring the necessary evidence. And I think that the reason why they failed to bring it is either they fell into an ideological trap and they brought in a bunch of anti-gun folks and didn't realize they needed somebody who knew the fundamental mechanics of guns, or they might have just been unable to find one. It might have been really hard to find an expert in firearm design who said, yeah, these are necessary, because the vast, vast, vast majority of guns on the market don't include these things. Okay, carrying on here. For the immediate case, the alleged defect in the M&P 40 was the absence of authorized user technology, which technology is alleged to provide a means to make a dangerous product less dangerous, i.e. it is a technology that makes the M&P 40 safer. However, in the immediate case, the matter of whether authorized user technology is a safety feature is a contentious matter that requires an expert's opinion. And the court is going to note why, because you might be saying, wait a minute, isn't this a safety feature? So authorized user technology does not make the use of a handgun safer for the user. It is essentially a safety feature against the handgun being stolen. This is true of authorized user technology generally, which is incidental to the purposes for which the product is designed. And they're going to give us some analogies here. For example, a cell phone equipped with authorized user technology does not affect the use of the cell phone as a cell phone, but prevents the cell phone being used by others and discourages theft of the cell phone. What sort of authorized user technology are we talking about here? Well, my phone has a password on it, right? And that password prevents, if I lose my phone and somebody else picks up the phone, they can't easily use my phone. I would actually say that the password on my phone makes my phone experience worse. I don't like having to enter in a password. And there's simpler ways you can use Face ID and so forth, but I don't like Face ID because Face ID could be used against my will. Without my choice, somebody could point the phone at my face, even though I don't want them to, and unlock it that way. Password, I pretty much have to cooperate in some fashion. But it actually makes using the phone worse. If I'm... as an example, my phone password is actually ridiculously long. I don't have like a 4-digit code, and there's reasons for that really deserve their own video. But let's say I go out drinking, and I don't do this often, but let's say I go out drinking and I get really smashed and I want to order an Uber to get home. It might take me 3 or 4 tries to get my password in because it's like 20 characters of gibberish. Okay, but it does help prevent it from being stolen and whatever, right? So it's not a feature that benefits me directly, it's a feature that impedes others who I think are jerks, like phone thieves. So, for example, authorized user technology is used in vehicles to prevent theft, but it does not make the cars safer on the road. And even in minimizing the crime of car theft, authorized user technology is not fail-proof. If you've ever had a car stolen, and I have, and it sucks, it was probably stolen notwithstanding the fact that it takes a key to get in the door and a key to start up the car. Thieves are good at bypassing authorized user technology. It's one of the things that makes thieves thieves, right? Is that they can bypass your security stuff. So, yeah. For example, cars are frequently stolen notwithstanding the presence of authorized user technology, and stolen cars may be used to perpetrate other crimes, including vehicular homicides. Like if you thought your plan to kill somebody was you're going to run them over in a car, you might think, might be a better idea to run them over in a stolen car rather than one whose plates point immediately back to where I live. So, the problem of the absence of a design expert in the immediate case was a multifarious problem. Multifarious is a good word. I got to save that word for later. There were 3 types of authorized user technology that were presented as feasible alternative designs for the MNP40. However, the feasibility of these technologies was largely theoretical feasibility based on the existence of patents and by the use of authorized user technology in other products such as cell phones and automobiles. In the immediate case, there was the possibility of prototypes, and some prototypes had been manufactured by other gun manufacturers. However, there was no evidence that the prototypes were effective, and no evidence that effective authorized user technology would not impair the utility or the safety of the handgun. Can you imagine like authorized user technology, but sometimes the gun just goes off on its own? Because I can. It's possible. Moreover, there was no evidence from a design expert about whether or not a decision to not incorporate authorized user technology was a decision that would not be made by a reasonably competent gun designer when the gun was designed, or perhaps when the gun was manufactured and sold. And the reason why you're not going to be able to find this evidence is because, like, every gun on the market does not have authorized user technology. This is a very, very uncommon thing. There's a few specialty guns out there that have it, and nobody buys them because nobody likes them because they kind of bad. So, in all events, it does not follow that because something can be designed, even something beneficial, that it is careless or below the standard of care not to implement the design. Further still, there was no expert evidence to show some basis in fact that radio frequency identification, RFID, and biometric technology were commercially viable design choices that would not impair the utility or the safety of the MNP40. There was no expert evidence to show some basis in fact that the authorized user technology could be incorporated without impairing the utility of the MNP40 for the user for whom the MNP40 was designed, which is military and police. And I'm just going to say, like, the biometric technology for military and police is going to be a complete non-starter. Why? Because they have to be able to shoot these things wearing gloves. Police and military both have reasons to wear gloves. Military may need to wear gloves because they're operating in cold weather environments, like Canada. I don't know why the Canadian military might ever need to operate in Canada, Yeah. Similarly, the police need to operate in Canada. We've got police everywhere from like sunny, warm, well, rainy, warm Vancouver, all the way up to Equaliot. And Equaliot gets cold, and I'm probably mispronouncing it, but yeah. Northern Alberta, Fort McMurray. Fort McMurray gets cold enough that let's just say don't lick any telephone poles in winter up in Fort Mac, or you're going to have a bad time. So, yeah. There was no expert evidence to show some basis in fact that authorized user technology would make the M&P40 safer for use by the owner of the handgun, or make the M&P40 safer for the public that might be affected by a criminal using the M&P40. Now, keep in mind, a criminal's gonna, is going to have time to bypass things. We'll talk about that a little later. Another problem for the plaintiffs was that design thinking involves empathy for the product user's needs and creativity in meeting those needs. The plaintiffs here had no empathy, I'm guessing, for the needs of target shooters, the military, the police, but just you needed to make it perfectly safe, right? Smith & Wesson designed the M&P40 for the police and the military. The thrust of the plaintiff's case was that the M&P40 should be designed with authorized user technology, even though this handgun was designed for the police and the military, because the M&P40 was sold and could be obtained and used by persons other than the police and military. This argument, which might be a good public policy argument, is not a good legal argument, because design negligence requires a risk-benefit analysis that does not ignore meeting the needs of the intended user for whom the product is being designed. Basically, your arguments needed to say how this works for military and police. Ironically, in the immediate case, there was some basis in fact that internal and external locking systems were feasible and could be incorporated into the M&P40 or other handguns. Indeed, the evidence was that there was a model of the M&P40 that had an internal locking system, and that it sold at the same price as the model designed for police and the military, which doesn't have the internal locking system because the police don't want it, and the military don't want it. It's just a potential problem. The problem for the plaintiffs, however, was that there was no expert evidence to show some basis in fact that all M&P40s would be safer for all users or for the public by the incorporation of internal or external locking systems. There was also the problem that the evidence from the plaintiffs' experts indicated that incorporating internal locking mechanisms was not a design necessity, because there were readily available external locking systems that could be utilized for users inclined to make their weapon unusable by others. So what they're talking about when they say external locking systems is this thing, the trigger lock. It works just fine. You can't pull the trigger with the trigger lock in place. That's what it's for. So do you need to add an internal locking system when there's an external locking system that works fine? Well, probably not. The other thing I'm just going to point out is this little piece on the handgun, this thing here. The purpose of this thing here is that it is a thing that holds the whole gun together. And what it's there for is so that you can pop it out and take the gun apart for service, for maintenance, for replacing parts. In order to use a gun, you have to be able to take it apart, because powder has fouling, it gets in the gun, it clogs things up, and potentially it can make the gun fail to function. You got to clean your guns. And any gun that can be taken apart to replace pieces or clean the gun or whatever else by the user, well, it means that the user can take it apart and potentially disable any such locking mechanism. It's just part of the problem here. Okay, so let's continue here. As a matter of design negligence, a legal, not political issue, the agreement does not show some basis in fact that an M&P40 without authorized user technology was a design defect that could have caused the harm suffered by the class members, or that an M&P40 with authorized user technology was a feasible alternative that could have been implemented at a reasonable cost. C, the implementation of authorized user technology would not have impaired the utility of the M&P40 for its intended users. And D, a reasonably competent gun designer would have chosen to incorporate authorized user technology in an M&P40 designed for police forces and the military. I'm not aware of any firearm that is designed for police and the military that includes such technology. I could be wrong, but I'm not aware of one. So, common issue number 2. Did the failure to incorporate authorized user technology in the handgun cause, contribute to, or individually harm or increase the risk of harm to the members of the classes 1 and 2? For the want of a nail, the shoe was lost. For the want of the shoe, the horse was lost. For the want of a horse, the rider was lost. For the want of a rider, the battle was lost. For the want of a battle, the kingdom was lost. And all for the want of a horseshoe nail, which is quoting Benjamin Franklin. Because there's no basis in fact for the critical common issue number 1, the design negligence question, it necessarily follows that common issue number 2, whether the design negligence caused harm, is also not certifiable, because the second one assumes that the first one was certifiable. Because of the likelihood of appeals, I will assume this judge knows he's getting appealed, so that's what he's saying here. I will assume that there was a design negligence common issue and consider whether there was an associated general causation common issue, i.e., okay, let's assume I'm wrong on that first point, so let's keep going and make that assumption and see if they'd win on this issue, even if I was wrong on the previous one. In the immediate case, applying the but-for test, and the but-for test sounds kind of dirty, but what it means is, would something have happened if not for the other thing, right? So let's say I'm driving my car along and I hit a telephone pole, and the telephone pole falls and smashes into someone's house. I can't say, listen, that's not my fault. The telephone pole hit the house. Because but for my crashing into the telephone pole wouldn't have fallen into that person's house, right? This is a sort of way to test for causation. Would the other thing have happened if not for the first thing? So there is no basis, in fact, for common issue number 2. Once again, what is missing is expert evidence, although this time what is missing is a criminologist to demonstrate that there's some basis, in fact, for concluding that adding authorized user technology to the M&P40 would reduce gun accidents and gun crimes of the nature that occurred on the Danforth. There needs to be some basis, in fact, to connect Smith & Wesson's negligence, which is not equivalent to a Smith & Wesson weapon being used by Mr. Hussein, to the harm suffered by the class members, i.e., would Mr. Hussein have just used a different gun? Would he have disabled the features in the gun and then used it anyway? These are problems that they needed evidence to get around. In the immediate case, no expert provides any explanation for how the alleged defect of the absence of authorized user technology is related to what Mr. Hussein did. Common sense does not fill the evidentiary void. Common sense might suggest that the presence of authorized user technology would be a cure for the nefarious use of handguns. This might be true for a child's use of his or her parents' handgun, but this is not the case they're bringing. However, in Canada, all private sector owners of guns, including parents of children, but not limited to, are already required to keep handguns secure from the use of others. As soon as I'm done using this handgun in the course of filming this video, it has to go back in my safe. And I'm still not taking the trigger lock off, even though I could for this, but yeah, it's got to be locked up, and so forth. Because it's going in a safe, I don't technically need the trigger lock. I'm just extra careful. All right. Thus, in terms of child safety, authorized user technology, while an added safety, is somewhat superfluous. It's extra bonus stuff. But the point remains that common sense does not explain why the absence of authorized user technology is a cause for what evilly happened in the Danforth. By the way, I do own one gun that has like an internal lock. And I can tell you the first thing I did with that is I unlocked it, made sure it was unlocked, and then I taped the key to the inside of my safe, and I have never touched it again. Because that's a key I don't want to lose, right? So I don't want to use it. So I have my trigger locks on combinations. The plaintiff's causation argument is that since there is some basis in fact that Mr. Hussein used an M&P40 handgun without authorized user technology to harm the class members, all of whom were injured by Mr. Hussein's use of the M&P40, And since Mr. Hussein would not have been able to use the M&P40 if it had incorporated authorized user technology, therefore there is some basis that the proposed class members suffered compensable harm caused by Mr. Hussein's use of the M&P40. Now, the reason why they don't want to sue Mr. Hussein is A, he's dead, but they could sue his estate, but I'm guessing his estate has like $12 and some buttons, and that's not really helpful. So the logical fallacy in this argument is that the harm caused by Mr. Hussein was his using a handgun, and while he happened to be using an M&P40 without authorized user technology, that is an incidental fact, but not a causal fact that connects Smith & Wesson to the harm done by Mr. Hussein. He could have used any handgun. The harm to the class members was caused by what Mr. Hussein did, and it was not caused by an aspect of how he did it. So again, this is the problem that all of these lawsuits run into, is the issue of, let's say somebody gets a sword, or, they get something like this thing. I like using this thing as a prop because it's fun. But, and then they go and attack some people with it. Well, is it the maker of this thing that is the reason for it? Or would it be whoever is swinging the thing? And the judge is saying, really, it's the guy who's swinging the thing you should be suing here. And the judge knows why they're not doing it. But just because a lawsuit is inconvenient doesn't mean it's, valid to launch some other suit. We happen to know that Mr. Hussein acquired an M&P40 without authorized user technology, but while the presence of authorized user technology might have deterred him from using a gun with that technology, it would not necessarily have deterred Mr. Hussein, whose circumstances are not known, from having been an authorized user of an M&P40 for the purposes permitted in Canada, and then misusing that gun. Basically, they're saying you didn't call any evidence that he wasn't the owner of this thing. Or it would not necessarily have deterred Mr. Hussein from circumventing any authorized user technology if the gun had been equipped with that technology. He could have taken it apart and taken it out. In Mr. Hussein's case, all of the authorized user technology might do is alter the means of his misdeeds, but not the occurrence of his wicked use of a handgun. I like the use of the word wicked. If I ever become a judge, I'm going to use wicked in decisions. These are reasons why I probably won't be a judge. But the point is that in the immediate case, while the plaintiffs are to be praised for their aspirations to find a means to protect others from suffering as they have suffered, it is for Parliament or the legislatures, not the courts, to legislate public safety product standards. Basically, you brought this to the wrong place. And our current government might be inclined to listen to them, but it's not going to get the money. That's the thing, is they can't get money from proceeding to, advocate with Parliament. So, skipping ahead, we get to the conclusion. For the above reasons, the plaintiff's certification motion is dismissed, which means this part of the lawsuit is dead. But they could launch this lawsuit separately as individual plaintiffs. I think they'll probably run into as much success doing that as they have so far. And the court also notes, if the parties cannot agree about the matter of costs, they may make submissions in writing, beginning with Smith & Wesson's submissions within 20 days of the release of these reasons for decisions, followed by the plaintiff's submissions within a further 20 days. Now, I don't have the ultimate costs payment that is awarded in this matter, but Smith & Wesson will be getting costs, and those costs will probably be a lot of money. And that may discourage this lawsuit from going any further because they will have spent a ton of money hiring these experts, although some of those experts might have done it for free or for discounted reasons based on their own sort of personal reasons. But I'm guessing most of them got paid and got paid a whole ton of money. And so they're going to be out that money, and then they're also going to be in a position of having to sort of pay Smith & Wesson and then restart their lawsuits from the beginning if that's where they want to go. So this might be the end of this particular lawsuit, or it might not. But for right now, the ability to buy guns in Canada is safe. And I think that's a good thing because we've got hunters, we've got target shooters, we've got competition shooters, all of those people. And yeah, the other thing I thought about covering it, but I did sort of cut it from my coverage here, is there was some discussion where the judge says both authorized and unauthorized users commit crimes with handguns in sort of equal amounts. There is a logical fallacy in the judge's decision. Maybe I could go through that again or in another circumstance or whatever else, but I did ultimately sort of decide to cut that one. Yeah, it's interesting here. This is an interesting case overall, and it's one of these cases where normally I would be concerned because the courts sort of try to bend over backwards to when you've got sympathetic plaintiffs. And I'm just going to say, I think the plaintiffs here are really sympathetic. They're completely innocent victims of a horrific crime. But that doesn't necessarily mean that you can sue whoever you want. And here, Smith & Wesson doesn't seem to be the big issue here. The other thing the court does sort of go over, and I did also cut this, is a discussion about they say a lot of the like misplaced guns or the stolen guns or lost guns in Canada are Smith & Wessons. And that might probably just be because Smith & Wesson is a very popular brand. I don't actually think I own any Smith & Wessons, but there's no reason why I couldn't or might not in future. But one of the other things they identify is that Smith & Wesson also provides firearms to a lot of police departments. And police have lost a lot of guns in Canada. So that might also be part of it. Anyway, I thought this would be a short video. It's a long video. That's kind of how I roll. But I tried to make it short. I probably cut like an hour of content out of this one. Easy. But thank you guys for watching. I hope you found this to be interesting or educational. Please like this video, share it with your friends, subscribe to see more videos like this, which will probably also be long. But I also want to thank my Patreon supporters at the $50 level, Purple Dragonair, Cielo, CMP, CCFR, PJs Forever, Canada's National Firearms Association, Bottle Shock in Oz, and the Canadian Shooting Sports Association. I also want to thank at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunk All of the Baileys, Cameron Johnson, Andrew Elsich, Marvin CZ, Dorky Dane. I think I left Purple Dragonair off the $50 level. I feel like I did. If I did, well, covering it now. I also want to thank my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time. And now I got to go put this into the safe. So, good night, everyone.